Go to, and we will get started. Thank you everyone for coming here for our, remember what number we are at, fourth meeting, fifth meeting? But yeah, there's a lot of work being done by quite a few objective work groups. And so today I'm really excited that there are two work groups we're going to be showcasing the work that they've done, and we're going to have a little bit of discussion around it. And then the rest of the time we're going to spend on our individual work groups. I have the names for people who had volunteered last time to be part of different work groups. So we're going to split out. One group's going to be here, and then we have reserved two other rooms outside of this space as well. So we can see, which group has a larger number. That way we can accommodate the larger room. Sound okay? All right, so maybe we can go ahead and do introductions very, very briefly. I know we have several people online as well, so welcome to folks joining virtually. I am Dr. Sonia Hirachan. I'm the co-chair of this MI&D Reform Task Force along with Sue Abderholden. I am the executive director and medical director for Forensic Services, which is part of Direct Care and Treatment. And then I'm going to let Robin introduce herself too.
Robin Bodie. I am the Director of Patient and Family Engagement for the Forensic Mental Health Program.
Good morning, Lisa Harrison Heather. I'm the Ombudsman for Mental Health and Developmental Disabilities.
Sheila Novak, family member. My son was at St. Peter for 12 years and has been provisionally discharged for about 3 years and lives in Jordan, Minnesota now.
Carrie Gallagher, Executive Assistant for DCT General Counsel Office.
Ann Zimmerman, Assistant Ramsey County Attorney, and I'm here on behalf of the NCA, the Minnesota County Attorneys Association.
Dr. Amber Lindeman, I'm a court-appointed examiner.
Cassie Sassenberg, Health and Human Services Director in Nicollet County, here on behalf of MAXA. Barb Wolfman Brecky, Scott County Commissioner, here on behalf of the Association of Minnesota Counties.
Megan Larson, I'm an attorney.
Becky Robinson, I'm the Forensic Mental Health Program Director.
And we'll move on to Dr. Griffiths.
I'm Josh Griffiths, Psychiatry Director of Forensics.
Andrea Martin from the Hennepin County Attorney Practice. I'm McNamara, just an observer from MHP.
Thank you. And then we'll move ahead on the line. Carrie, do you want the line just on?
Marshall.
Marshall.
Yeah, good morning, everyone. I'm Marshall Smith. I'm the Health System CEO for Direct Care and Treatment.
Sue.
Sure. Hi, everyone. Sue Abderholden, Executive Director at NAMI, Minnesota. I'm sorry I'm not there in person. It's kind of a hectic time at the Capitol, so thanks for your grace.
Thank you for being here. I know it's been pretty hectic for a lot of people. Thank you.
Yeah. Delane.
Delane.
Delane Remish with the Minnesota Disability Law Center, the Protection Advocacy Organization in Minnesota. And I too am sorry I can't be there today. I have a training with a new staff person. So thanks.
Thank you for your time.
I'm Dr. Keith.
Dr. Heath.
Ian Heath, Senior Medical Director for the Psychiatry Service Line at Hennepin County Medical Center. I hope to be there for the second off in person.
Great. Thank you.
Michael Thompson.
And then Dr. Thompson.
Hi, I'm Michael Thompson. I'm a psychologist in private practice in Minneapolis. I'm simply observing. Thank you.
Great.
Then Tim Carey.
And then Judge Carey.
Good morning. I'm Judge Tim Carey from Ramsey County, and I am unfortunately unable to be there in person because I have mental health court staffings later this morning. But thank you.
Thank you for being here. We really appreciate everyone's time. So we do have a good agenda for us in front of us today. So like I said, we're going to be talking about the findings from the two work groups that have been meeting quite regularly. But before we go into that, just wanted to have a little bit of space and time to reflect on the open mic session that we had last month. I know Sheila wanted to say some few words as well, and then really would want folks to, kind of reflect on that. There were a lot of stories that were shared, and, we, as a task force and as members of, various organizations that we serve, we talk a lot about numbers and, these are the numbers and, this is these clients from Hennepin, Ramsey, what have you. But when we actually have real people and real families come and share stories, it's very impactful. I felt very much, touched and lots of emotions at the end of the session. So thank you for bringing that up, Sheila, that you wanted a little bit of time. So do you mind talking about it?
Yes, first of all, everybody wants to thank you for giving them that opportunity. And it was, maybe not exactly addressing all the questions that people were supposed, but I think it was much better because it was really from the heart. And, it personalizes what we're doing here to hear those stories. But I did talk with everyone who spoke here last time, and they did feel that, it would be nice to get some feedback as to what you thought about that, because as you mentioned, it kind of ended abruptly. And so I don't know if there's anything that I can bring back to them, your reactions, your thoughts.
One of the things that we did talk about as a group, objectives 1 and 2, is that in our overall report, the recommendations report, we would have a section dedicated to, what was shared by the families. So perhaps that's one thing that you could share
Yes.
back as well.
Sue has her hand up.
Sue, did you want to say something?
Yes, Sheila, I think you can let them know that it was really, I mean, you know how much I believe in people's stories. It really is helpful to hear from people. And I think what it also told us is that that so many of these things start way before, right? That when we think about how do we prevent people from becoming committed as MI&D, ending up at the security hospital, there's things that we need to do way ahead. And I think that's just, it's an important thing to remind legislators of. There's some discussion right now about the Commitment Act and, implementation. It's like, if we don't have a community mental health system, it doesn't matter what you do. And I think we all know about all the issues about boarding right now and long wait lists. And, Ramsey County is hiring, 80 people to catch up on all of the min-choices assessments. And so we know all these kind of blockages in the system. So I appreciate that they shared how it all happened and not just what's happened since they've been in the security hospital, because I think that helps us as well. So please thank them for me for really, in some ways, having the courage to publicly speak about their family situation.
Thanks, Sue.
Thank you, Sue. Any other thoughts from folks?
I'll just share that even though a family spoke who their child is committed as MI&D now, waiting, coming to St. Peter.
Yes.
And to hear the fear
Oh, yeah.
and the stigma, and just how scared they were for their child hit me hard.
Mhm.
Shows me even more we need to do more to share the success stories too and the positive stories. And I don't want to self-promote, because it's not like we're looking for business, but that we have a lot of caring people that really do invest in recovery and want people to get well and don't want people to stay in the hospital
Or in jail.
or
He's
or
been there
or
for
right or
almost
in
10
jail. I mean, it's just
Yeah. And yes, I appreciate you bringing that up. I've gotten to know, because there is a support group for family members who have someone at St. Peter, and this family is waiting to get into St. Peter.
right.
And so one of the reasons that I go there really is to say exactly what, to dispel that fear, even though, I mean, the whole thing is scary
Right.
when you're first going into a program like that. But they, they're hoping their son can go there rather than prison. And so you want them to go into this with a positive frame of mind. And that's, in my experience, it's not all perfect, of course, but the overall end result is very worthwhile. And so, yes, they need that reassurance. So yes, it's a good point.
I'll just say that in our work group, when we've been meeting, I'll just say that, and I don't know how to express this in a better way than just to say they were heard, like we heard them.
Okay.
And we took their feedback, so it wasn't falling on deaf ears, because a lot of what they said came up in our work groups.
I appreciate that also. Yeah. Cause I'm not hearing too much right now, but if they were heard, that's the main thing. So.
This is Lisa, I wanna reiterate, what's been said about just how impactful it was, and frankly, how viscerally some of those stories, touched me, and hearing that these are all individual people, individual experiences. We've talked a lot about numbers and capacity and all of those things, but one of the things we hear from folks when we talk about public engagement and trying to gather stories and voices in groups like this is a lack of kind of closing that feedback loop, excuse me. And so I wonder if it might be something for this group to consider once the report is issued, allowing some time and space for those to provide feedback to what the recommendations were, if they heard their stories and their experiences be reflected in the final report, and just to maybe offer a space to listen again, not only to what their stories were, but then to listen to what their response is to the report that this group puts forward.
So you're saying you'd want to show them in the report how what they said had an impact on that, but also give them a chance to verbalize that again?
To respond to it in some way, whether that's a
Yeah.
survey, whether
Okay.
that's written comments, whether
Right.
that's another, opportunity for them to speak to this group. But I think that so often in state government, we ask people for their opinions
Mhm.
and their experiences and their stories, and then we don't really clearly communicate to them what we're doing with that and how it's informing the direction that we're moving forward as a task force or state government or the bureaucracy of it all in general.
Great.
That's a great point, Lisa. Thank you for bringing it up. We can definitely take that into consideration as we're drafting up the recommendations. Any other final thoughts?
Thank you very much.
And thank you, Sheila, for
Yeah.
making
Really.
mention of this. Yes. Okay. All right, so we'll move ahead into the agenda. First is the work group, the first work group, which worked on objectives 1 and 2. We've met several times now. Several of the members are actually here as well. And there were a lot of different research, directions that we could have gone to. And what we ended up doing was that we looked at what are the national trends for indefinite commitment within the country. We also looked at, what kind of civil commitment statutes and laws are out there for different states. And then we looked at our own Minnesota Judicial Court, Minnesota Judicial Branch data as well. So in your handout, you do have that. The first finding that we're making note of is that referrals for MI&D admissions across DCT have increased by 110% between fiscal years 2015 and fiscal year 2024. So you can see that one of the greatest jumps happened between 2020 and 2024, 32% increase, and then 42% increase within the last fiscal year. And the other thing to also note is that before 2019, we actually had the Forensic Mental Health Program had the Competency Restoration Program, which was actually dedicated to Rule 20 patients. And after 2019, we actually absorbed those beds into the larger Forensic Mental Health Program to accommodate the growing MI&D population. And I don't think that we've talked about that quite a bit in the public space yet. So we just wanted to make note of that.
Can I ask where that competency is taking place now?
So we I shouldn't say no longer. We didn't have a statutorily mandated treatment for competency restoration. So what ended up happening is that shifted primarily to an Okametro Regional Treatment Center.
Okay,
at that time. Right now, we are operating under Chapter 611, so even that is operating within AMRTC. So the second finding is that within the Minnesota Judicial Branch, which kind of mirrors what I just talked about, that MI&D commitment orders have increased by 77% since 2014. And they averaged at around 48 commitments from 2018 to 2020. And then 2022, we had the largest increase at 48. And then this in 2023, we've had 55 commitments ordered. 2024 data, we're still looking at it, but I would say that it's probably going to be at that number as well. The third finding is that, again, the data maintained by the Minnesota Judicial Branch shows that the number of MI&D cases filed that resulted in an MI or DD commitment has ranged between 8 and 16 per year from 2014 to 2023. So while overall national trends show that there's 76% increase in the number of forensic patients, and the term forensic is used very variably amongst different states. So in other states, it's primarily, looking at your Rule 20 patients who've been found not competent to stand trial, not found, not guilty by reason of insanity. Those are your forensic patients. And also your civilly committed sex offenders. Those would also be counted under the forensic patients. The trend is not consistent across all states, but again, because of the definition of forensic, that probably played a factor in this as well. And for many states that have been experiencing increases in the forensic inpatients, that's mostly because of the incompetent to stand trial population. The fifth finding we looked at was that according to the NRI report in 2017, number of things that, other state hospitals are doing in order to cope with the rising number of forensic referrals. They've built a lot of beds, they've adapted the admission process, modified prioritization of wait lists, built community or jail-based programs, that's your outpatient competency restoration programs, and then foster relationships with other systems. And wanted to make note here as well, and we talked about it in our work group, is that all of these things are things that we're also doing. We've expanded our beds, we've modified our prioritization frameworks as well. And then we also have outpatient programs as well. The sixth finding that we saw was that Minnesota has two separate categories for commitment. One is a person with a mental illness who poses a risk of harm, which is your straight MI commitment. And then the other one is for a person with a mental illness and who is dangerous to the public. And dangerousness here is defined as a clear danger to the safety of others, as demonstrated by the facts that the person has engaged in an overt act. And then there's a substantial likelihood that the person will engage in acts capable of inflicting serious harm, physical harm on another. So what it all boiled down to is that while, other states have different ways of committing someone, through the forensic route or even through the civil route, for Minnesota, we employ a single civil commitment-based pathway to long-term secure treatment. And so because of that, any slight increase or any slight broader interpretation of the statute will invariably lead to a larger inflection within, with us not having the appropriate beds, basically. So that was the findings that we discussed with our work group 1 and 2. Like I said, the full packet is within, I think Harry did print them out for everyone. So if folks want to take a look at that, or if folks have any questions about what I just talked about, would be happy to answer any questions. I know we have several members from the work group as well. Right here.
Email that to the members.
Thank you. And they have been emailed to the members as well. Any questions? Yes, Andrew.
Yeah, was there any statistics or any information if they had if these other states that have this higher threshold, if you will, have more like in longer term treatment facilities as alternatives to their version of FMHP? Because I know we've talked a lot about NITO in our work groups, and we talked a lot about there not being state-run alternatives that can take persons for a longer period of time. So I'm curious if those other states have those resources that we don't presently have.
I will look to Dr. Griffiths, who did majority of the research there. Did you have anything, Dr. Griffiths?
Yeah, I would say that, I think of how to, I think it's difficult to have sort of an apples to apples comparison. As far as state-run resources versus, those are financed through some sort of health insurance or other things. As far as long-term secure treatment is considered, I do think that you have a significant subpopulation of individuals that are, in other states accommodated in a DOC setting that have either been found competent and been convicted, and so there's pretty significant infrastructure of residential treatment within the Department of Corrections. So a lot of states have sort of residential facilities for people with chronic, and I think that there are varying perspectives on that as far as where their Department of Corrections is a ideally suited institution. I mean, forensic hospitals are tough because they exist in some sort of in-between space between sort of traditional healthcare settings and correctional care settings, and so they frequently have sort of a hybrid. And I think every state tends to draw that balance a little bit differently. Some of it, I think, is related to how, and I think this is addressed in the work group report as well, is just the legal thresholds that have to be cleared in order to be admitted, if you will, into or to access particular secure treatment resources. So whether that's a secure treatment resource within Department of Corrections, or whether that is somebody being held competent to stand trial, and they're still sort of deemed not safe to be held in a community setting, and so often they would go to a state hospital, or whether there's somebody meeting civil commitment criteria that are then committed to a quote unquote civil hospital. So I think that's where it's tough, is because all of these systems have developed on a hyper local jurisdictional basis, and so it's even difficult to get a similar definition of terms, because the term state hospital in one state means something very different than in another state. And I think to me, I feel like it's better to talk about it more in universal terms around sort of public safety, and then sort of and secure treatment, and then sort of what does a person need to be treated in the most integrated setting possible. Because I think those are more universally accepted principles. So I'm sorry, I think the main thing is that every state uses different resources as a means of meeting the needs of individuals, and those have benefits and downsides, and there's philosophical and moral benefits and downsides to those resources. But I would say that the barrier to entry into those resources, I think, is in a lot of states higher than mentally ill dangerous being somewhat of a it's not, I think it can mean different things to different folks depending upon who's interpreting the application of that. But if the application of that label becomes synonymous with guaranteed secure treatment bed in perpetuity, you know, and we end up sort of with this bed deficit that we've had for over a decade. And that's reflected in the numbers.
Out of naivety, did those other institutions tend to have the threshold of some sort of criminal charge? And that,
Yes.
Yeah.
so that's what you're talking about, it's like the MI&D.
That's where the distinction between, because so if you look at the NRI report, I think it's funny to go to national conferences because people are like, well, what do you do with your forensic patients? I'm like, well, technically none of our patients are what people call forensic in other states because they're all civilly committed. Whereas most other states are often managing this population under the jurisdiction of the criminal court. And 611 has gone in that direction somewhat to sort of introduce some criminal court supervision. But I do think that there usually is some sort of criminal charge that has kicked off this process, and usually it's for folks that are detained long-term for secure treatment, it's usually some sort of violent charge that it's pending, and either they're not competent to stand trial or they are found not guilty by reason of mental illness or something along.
Or if they're found not competent to stand trial, the prognosis would have been very, very poor and the charge would be higher, like a higher charge, and then that could.
Exactly. So then those are referred to as sort of Jackson states, where they kind of follow the Jackson ruling, where they run into issues as well. I mean, I know that then it becomes if somebody has gotten to their Jackson limit and they're starting to kind of push back on how long of a time they can spend in a secure setting while being restored to competency. But whether the civil commitment system laws are sufficient to allow for that person to then be civilly committed once their ability to be held under Jackson expires. So if it's a murder charge, then they don't tend to run as much issues with that. But if it's a significant assault and in a person that continues to have sort of psychiatric symptoms that an ongoing risk of harm to others, then the question is, well, does this person meet civil commitment criteria? That can we then drop their charge and civilly commit them because we still feel like they're in need of secure treatment? And those cases can be difficult, I think, in other states as well, because MI&D exist. And there's a whole literature out there around this of sort of people that are not competent to, not competent, not restorable, and still assessed to have a community risk of harm to the community in their current state, because other states don't have it. It's not an option, and so there's sort of talks about sort of special procedures of sort of implementing an NGRI without that person necessarily being found competent, and there are other models that other states have done, but MI&D is not an option in those cases.
Right, and I guess my question was more along the lines of, I see the numbers statistically have gone up since about 2015-ish. And so my question is, MEDO closes in 2011, Rule 20 start to kick up around that time. The state stops doing competency attainment in like 2018, and we have this consistently high level now. And so my correlation or my question is this a problem really with the statute, or is it a problem with the resources have narrowed to the point that the last resort has now become much sooner in the process than maybe it was in 2015?
That's a fair point. And what I want to clarify is that we never stopped doing competency attainment. The program as we had, run that program ended, but then we never stopped providing competency attainment services. So just wanted to make clarification, and I know that Sue has her hand up for a while. Sue?
Thanks. I mean, I do think it's important to recognize that we do it differently here. So it's really hard to kind of look at other states. And the mental health systems, you've seen one mental health system, you've seen one mental health system. And, in many states, especially in the South, I mean, they don't have community services. It's basically their state institutions, even for a very acute level of care. Their community hospitals don't do that. And so I think it becomes difficult. The one thing I just want to say, though, about competency restoration is we know that the number of people deemed incompetent has gone exponentially high, not just in Minnesota, but across the country. And, that task force that met, several years ago for 2 years, we never really could figure out why. Was it math? Was it stress? Was it, no one in other states could figure out why either. Was it just that attorneys and judges were more aware about mental illnesses? But I think that high number has also placed incredible stress on our systems. I mean, there's still more work that I need to do on this. It's just when the legislature pops up this time of year, it's just I can't really do anything. But I do want to talk to some of the other states. I know that Maryland right now has a bill that's redoing their special review board because they were having problems with it. So I have a time to meet with them next week to just learn more about what they're doing there so that we can find some states that are at least somewhat similar so that we can also kind of figure that out as well. But, I just think it's important to note, most other states don't do it like we do, which makes it in some ways more difficult.
Exactly. Thank you.
Well, and I would say to piggyback on Sue's point, that I think Minnesota, by comparison to a lot of states, is a more well-resourced system than I know that there's a lot of concerns about this, the resources and the ways in which those resources are targeted. But I do think that our system is in my experience, more well-resourced than a lot of other systems. And so I do think, and I would also highlight that the incompetent to stand trial expansion issue is a national trend, and nobody can quite figure that out. I think it is a multifactorial things. I mean, I think that there was a couple of presentations a few years ago from California about homelessness and housing. A lot of people pointed to housing costs are just sort of like a people that are kind of on the precipice of sort of falling out of their social network or social safety network. That sort of economic strains being a component of that. But that's a very difficult thing to prove definitively and pin down. I think methamphetamine has been discussed, but the federal government stopped collecting data on use patterns of methamphetamine. So it's really hard to even trend back in 2013. So it's really hard to even make any connection between sort of methamphetamine use and whether that has any impact. But I think it's certainly something that it seems to be correlated with the ISD population we work with. But I think to your point, and I think that's the $100 million question, sort of what does this expansion do to, but I do think that I don't necessarily think that it is 100% a resource issue that is related to resource cuts. So it certainly could have exacerbated the issue, but I don't think that they necessarily are part and parcel of the problem.
Can I ask a question about number 8 as well? I don't see where it says what makes our threshold lower than other states. I mean, that's a pretty strong statement, so I'm just curious as to what the legal basis for that is.
Sorry, I have to take a unit call. I can speak to that as well.
Any other questions while we wait?
Well, I was gonna maybe talk to him a little bit, but I can bring it up now. It's been brought up a few times about this idea of some sort of an interim program prior to full-on placement at St. Peter. And it seems like that could be a place where competency could occur, assessments could occur, a determination of what that person needs long-term. And there may be many different options that don't include St. Peter, which would significantly reduce the number of beds that are taken up by people who really maybe don't need to be there. But I think there it seems like there's kind of a little bit of a knee-jerk reaction from this point to that point, and the only in between is really jail. So I don't know if any other states have any program that does that kind of thing that we could maybe look into and emulate, not reinvent the wheel, or maybe it's just a bad idea, but personally, I think it's a good idea because some of the people that we talk to, you know, really the offense and the length of time that they're ending up at St. Peter is just, I mean, if they had gone to prison, they'd have been out in 2 years, you know, untreated. I know that. But at the same time, they look back and say, you know, they were in court. They didn't really understand the process. And all of a sudden, they're at St. Peter. They have no idea, you know, 10, 12 years later, that that's what was going to happen. So.
Judge Carey has.
Judge Carey.
Yeah, thank you. I just, to that last point, we most often can't resolve the criminal matter because of the untreated mental illness and because of the acuity of the symptoms of the mental illness. So we can't really revert back to, well, this would satisfy the prison sentence because we can't, the criminal process is suspended. So that's, I think we all wish that the criminal sanction time would comport with the time it takes for a person to be well, to be reintegrated to the community in a safe manner. But that's kind of an artificial standard compared to meeting the person's treatment needs. And I also just wanted to say as a person who's tried these cases as a lawyer and who has heard these cases as a judge, we do a really thorough, less restrictive alternative analysis. And part of the analysis before even filing a petition, at least when I was trying the cases as a lawyer, was, have we tried everything? So what happens when we have an ACT team plus community hospital plus the structure of a pending criminal case that includes pretrial supervision? And if it's more violence and the kind of violence that is contemplated under the statute, we do get to a point of running out of options. And that's part of what I'm really concerned about, is that there's kind of an assumption that we aren't including that requirement under the law in the analysis that causes a person to arrive in the facility in the first place.
I guess I was seeing this more as also a very security-based kind of place. It wouldn't be a place where, you know, the security element is gone, but it would be a stepping stone. Because right now, you know, one of the people that spoke last time, 10 months in jail, you know, maybe, and they're doing assessments. The family doesn't even really know what are the assessments they're doing. And they could have been in another spot that would address their mental health issues and assess them for where they need to be next. But, okay.
Yeah, no, I think your point is well taken, Sheila, and you know, we do need, that's why we're all meeting here,
Yeah.
right? Is that this is the problem, because there is no in between. Then where do we dedicate our resources? What can we
Right.
recommend as a task force? Because really, like you said, the security that we provide in a 12-inch ruler, that's number 12, right? Like Marshall talks about.
Yeah.
Right, so where are the 11 other steps, right?
Right.
How can we talk about it?
Yes.
Where are those recommendations that can come from? So thank you for bringing that up.
Yeah.
Dr. Griffiths, do you want to take on the question about why do we have a lower threshold? Not why, but
Yeah, I
Where
just
was
was
your
saying
analysis?
because of that forensic piece of things, so, I'm sorry that this guy, because I've been come specifically prepared to talk about these questions, but,
so maybe
I
we
would
can
say,
start with-
in other states and sort of as sort of conceptualized, to have a long-term access to a secure treatment facility, have sort of three routes to get there. There's found guilty of a violent offense, and placed in some sort of residential environment for a long period of time within Department of Corrections. That's the first, and we talked about sort of the, issues with those that having Department of Corrections running a secure treatment facility, but other states do that, and that is, there are people that would help sort of long-term, in Department of Corrections for that. And so I would anticipate that a decent proportion of our current patients, if they lived in another state, would be placed in a residential treatment center. Because of the way that their laws are interpreted and written. Second option is sort of the incompetent to stand trial population. So this is somebody who has generally a violent offense and is going through competency attainment. And so in a lot of states in the past, if you were found incompetent to stand trial, you were sent under the jurisdiction of the criminal court to the state forensic hospital. And a lot of states generally had one exception, maybe, Texas and California have a few possibilities. And so with the explosion of IST sort of countrywide, that it has become no longer an option. And so there have been efforts in a lot of states to build a larger continuum of care around incompetent to stand trial, such that there is, there's that analysis around sort of what does this person need to be successful based on the level of the offense, the potential penalties related to that, potential criminal sentence related to that offense, and the probability that that person will be ultimately attain competency. And so we have some information about things that are prognostic related to a person's ability to attain competency. And so there has been a lot of efforts to sort of identify who among that IST population that have long-term competency attainment needs need a sort of a facility like forensics, a forensic psychiatric hospital, in the traditional sense of sort of having that sort of hybrid of healthcare, but also having a lot of security. And so that's sort of the second route. And those states that don't have an MI&D option, which is, I'm actually not really familiar of another state that has the capacity to just sort of take somebody, but a lot of states have differing civil commitment laws that allow for commitment upon somebody sort of reaching a sort of threshold for exit, or prior to that, if they're deemed non-restorable to sort of civilly commit folks. And so and there has been a lot of discussion, and there's an article I can send folks about it, about different models, about addressing folks that have sort of competency, they're being held for competency, and there's still concerns about their community safety risk. But they're either butting up against a limit for secure treatment imposed by Jackson, or there's not an alternative sort of commitment process that will sort of ensure that long-term treatment. Because generally, sort of Most states are limited by having that sort of MI only as a possibility. And so it's sort of like the focus is more on recent behavior. For that MI statute, it's more related to, and it's something that the burden tends to be on the state on a 6 months, 12 months basis to sort of come back and prove that that civil commitment is still indicated, as opposed to kind of here where it's sort of MI&D is placed in perpetuity, and then the person gets the opportunity to kind of plead their case every 3 years at least, but they can petition up to every 6 months. And so that skew tends to kind of be towards a precautionary principle that oftentimes will lead that person to kind of be detained for a long period of time. But there are some cases, when I practiced in Colorado, where the violent charges were dismissed, and that person just sort of remained on perpetual civil commitments, and there were continuing symptoms and other things like that. But there was a risk assessment, and there was a pretty intensive process that went into every 12 months or so, ensuring, demonstrating that the placement within a state hospital setting under civil commitment was a least restrictive alternative. And then the third group is NGRI. And honestly, it's interesting because I feel like when I talk to people in other states about MI&D is the treatment model for MI&D in our state is synonymous with the NGRI population in other states, where there's sort of this long-term indeterminate commitment, where people are sort of, it's placed on the person in perpetuity, and they are stepped down through sort of least restrictive alternatives. And I know in Colorado up until there is a little bit of difference as far as like how much of a least restrictive analysis goes into after somebody is found not guilty by reason of insanity, as far as whether they just anybody with an NGRI goes to the state hospital. I know that in some states that sort of was just like, well, if you're found NGRI, you're going to the state hospital. And so frequently people would only plead NGRI for cases if there was a significant there was a significant benefit to it, because if you plead NGRI for stealing a purse or something like that, chances are you could end up going to the state hospital for a decade or more. And so it was generally something that was employed more for higher level charges, where I do think that there's a little bit more of an analysis that goes into that, because the finding of NGRI is not connected with the civil commitment process. It's kind of separate. And so that the person has to have that finding of NGRI, but then they could be civilly committed as MI&D or not. And so those are completely disjointed. Most states have the NGRI finding is coupled with some sort of indeterminate civil commitment process. But it's usually it's not a civil commitment in the traditional sense, because it's usually, some states have sort of an administrative body that oversees it. So like Oregon has the PSRB that reviews all of their NGRI equities. And there's a number of states that practice that model, which is, I think, similar to Minnesota. But then you also have a lot of states where the NGRI population is overseen by the criminal court. So there are any reductions in custody, you have to go back to district court and argue this person is guilty. So those are kind of the three buckets, but they it's not just something that you can, somebody has a violent offense and you can immediately petition for it and determine. It's like there has to be either a period of competency attainment that goes into that process, and the finding of non-restorability, or there needs to be finding of NGRI, a person that attains competency and as done in GRI, so in all three of those cases, there's a lot more, there's certain criteria that have to be met that don't necessarily like, it's more, whereas the MI&D, and once again, I don't want to necessarily say that, and I think it was maybe the judge that was speaking, I don't want to necessarily make that a criticism, because I appreciate, I know when I first moved here, I was like, man, this MI&D statute seems like it's wide enough to sort of just drive a truck through, because it's like, it just seems like it's pretty arbitrary, and I do think that there's been a lot of appropriate analysis that goes into, you know, interpreting the statute and what it was intended for, and but I think, first of all, having that MI&D commitment coupled with placement at FMHP can do some cases a disservice, and I know that's why we've kind of worked on diversionary efforts and other things like that to try to identify alternative, and these are difficult cases, so I don't want to say there's always necessarily an easy answer, and I can see why, you know, there's sometimes our facility just ends up being, but for each of those additional cases, I mean, we're talking in the order of placement in our facility for a decade or more, that, you know, you have one county that interpreted the statute in a weird way 10 years ago, that person is still in our facility taking a bed. So like, these are all debts that kind of accumulate over years. And so it's not necessarily to point a finger at any particular county or any particular stakeholder, but it just is set up in a situation where that it's the application of that MI&D indeterminate commitment it can be done before things really get that sorted out with the case. And once it is in place, it can be very difficult to remove that or to identify alternatives, because, you know, we don't, it's not under our control at FMHP who comes and goes. You know.
Yeah, please thank you, Dr. Griffiths. We're really behind on our
I'm
agenda.
gonna say, I'm sorry.
Yeah. No, that's okay. I think these were all good questions. And
Sue has her hand.
oh, Sue. And then
Just
we'll
real quickly, we still need to do some, you know, fluffing and buffing of this section, you know, to kind of, you know, really pare it down and things like that. But there is one issue I do want to raise, and that is the disproportionate number of Black men who are committed as MI&D. And, you know, it's hard for me to believe that they're really more violent. And so it's something that I think as we look at recommendations in the future that we also need to look about in terms of, you know, is that disproportionality still there, and what can we do to address that as well? Might be lack of resources, you know, not knowing there are some culturally specific providers in the community, things like that, but I just don't want that to be lost in this discussion. Thanks.
thank you for bringing it up, Sue. And then I will move on to Cassie. I think you're going to talk about objectives 5 and 6.
Sure, and so we went through a lot of this last time as well, so I'll just try to summarize. We will have information to send out soon. We have most of the information put together for human services, county attorneys, examiner feedback. We did in Sue has the report that we have generated as a draft to add in all of the friends, family information as well. A lot of it ends up kind of with the same recommendations, but different content to support them, I think. So we started off really exploring beginning to end. So a lot of our information is about the assessment and evaluation process as a whole, thinking about avoiding MI&D commitments when possible, as well as that separation of MI&D commitment, meaning forensic mental health program, as well as some barriers to discharge. So looking at the assessment and evaluation process, I think Sheila started us off exactly as to what our group has been focused a lot on, which we heard, I think, from family members as well as from all of our other stakeholders, that the assessment process doesn't feel like it's always capturing a person's clinical needs as well as meeting other of their needs. We talked a lot about people having their final commitment occur in jails or in community hospitals, where there is not necessarily treatment provided. There's not necessarily people trained to provide that kind of observation and intervention that would be needed. So we talked a lot about the development of another facility that does these assessments, so there's more detail in our report, but we also broke out how the process could be changed then to support this separate system. Thinking about how sometimes a shorter time for assessment is appropriate and other times we would want to encourage that year that's allowed in statute. So we explored why that might not be something that people elect to utilize, and how a separate facility with separate assessment teams and observation and treatment could allow for that. So it doesn't necessarily change the statute, but it's developing things that would maybe assist in being able to leverage the option that statute allows. Let's see.
And I think a big part of that was, we don't really have less restrictive options. So it's in statute to have less restrictive options, but there's nothing that actually would meet the need of the individual. And so a lot of places, IRTs will not take people with certain offense types. You know, a lot of places have been rejected, or the violence or the aggression that's happened. They don't get to have those services. And so really trying to slow that down a little bit to say like, okay, a state-run place would be an option before you start getting to St. Peter would be great. So.
And we talked about how the statute allowing somebody to be diverted from the forensic mental health program as a whole also isn't utilized because there aren't those options either. So if this slowed down the process and people could be evaluated for a longer amount of time, see what their needs are, lesser restrictive options might be recommended by an examiner or by a county attorney. And then we would need those lesser restrictive options in addition to this phase that's assessment, talking more about like state-run homes where we know that people might be there for a long amount of time, but as a preference to the forensic mental health program if that wasn't needed. A big piece for us there was making those state run so that they're not privatized. We've talked a lot about in this group already about all of the gaps that exist in that area for training, for staffing, for willingness to take people who have had any dangerous behavior. We also talked about ensuring that they are regional so that there are locations for people to go across the state that might have them closer to their natural supports, family and friends, as well as services and case management.
So maybe I missed this, Cassie, but was there, and you said there are issues with privatizing these places. So can you talk a little bit about those barriers there? Because it sounds like, at least again, just from the outside, it sounds like we're wanting more state-run facilities, which again, there are problems with that as well, because we did have that back in the day. And so there's a reason why we came here, right? So I just want to get more information about why the group went that direction.
Yeah, so for the thinking of not a group one, but I mean, traditionally what we might think of in that way. A lot of struggle in the community exists for those alternative placements prior as well as discharge, because there are homes that counties don't feel comfortable discharging people to because they're not well trained. Staffing is difficult, benefits, pay, all of those things fluctuate from private providers. Private providers also have long wait lists. And so they might have somebody who has had almost no struggle, and then they might have somebody who has complex needs and has had years of struggle. Frequently, our providers are going to select those who have not had much of a struggle. A lot of our private providers in the community may have, somebody might experience a crisis and things aren't going well in the home. They might be quick to discharge. Like somebody might get a few days notice and have to be discharged and have no alternative options. So there's a lot of different factors that have led to that. I think it's also led to chunks of developments across the state. So you might end up with one area, my county is one of them, where you have some providers who have had experience at the forensic hospital. They are wonderful providers. It's easy, not easy, but they're equipped to work with a population that has these diagnoses, these difficulties, and build a great program. But then you have everybody in one area away from their services, their family members, their providers. And so having that more consistent across the state, I think also would assist in being able to prevent on one end as well as allow discharge options on the other. So we sort of included this at the beginning of our report and at the end. Same with the assessment facility. We called it a couple of things, but like crisis stabilization and assessment, we have a few acronyms that have
when you.
may or may not stuck. But thinking about how that might also be used instead of revocation. If there was this crisis stabilization center that wasn't stuck at a certain number of days, maybe wasn't within the secure perimeter, like there would be an option for people to go back when they're struggling in the community, go back, have stabilization and medication changes, and then hopefully return back to the home that they left. They identified as part of the private settings as well that the beds are held for just a brief amount of time. So if somebody needs to return, whether it's a revocation or an extended hospitalization, that setting might not exist for them anymore, which might further the likelihood of revocation. We spent a lot of time trying to talk about less ways to get to the SRV and CAP process, because we recognize for many of our clients, they may need longer to stabilize, but the second they go back under a PD or are committed MI&D right out of the gate, you enter the SRV CAP process. So we spent a lot of time talking about how do we set up services and resources to avoid getting to the point of needing those extra levels so that the person can continue to move forward, whether that's still in a couple of years or in a couple of months, because we recognize that not every client needs to have those 6-month, 3-year risk assessments, because the county case managers know them well enough and know what they need. But we recognize that that has been a complaint about the discharge process from St. Peter is the SRV and CAP process. So how do we avoid having to go down that process every single time somebody struggles?
Sure.
Because we know they will. It's part of life.
And I would say from the other states, the number of patients, at least in my personal experience, that are on sort of SRV CAP type processes in other states is quite a bit smaller. And I do think that that is an impediment. Once it's sort of in place, it kind of is there in perpetuity. I know there's different legal routes to that than there is here in Minnesota, but I would say that generally the population. The other thing along your point around revocation around other states as well, as a lot of other states don't, if there is somebody that is on a SRV CAP type process and they're reintegrating in the community and their setbacks and relapsing and remitting illnesses that we deal with, there's frequently some barrier to just coming all the way back to, I don't know, mothership, if you will. So I think that I agree with that point as well, as sort of having some intermediary steps, whether that's what would be called a civil state hospital. I mean, a lot of other states have their sort of civil state hospital, the forensic state hospitals, and they may go to a civil state hospital or another sort of long-term stabilizing process before necessarily being revoked all the way back to the state forensic hospital.
I would just, if I can just add real quickly, we wove in also some avenues to explore for those who have had repeated MI commitments to be able to go to this crisis stabilization and assessment facility as well. Thinking that this option might assist in providing some triage and next best service for people to avoid the MI&D commitment as a whole, as well as this allowing for some options like a stay of commitment or the PD that we've talked about, or maybe somebody ends up that the initial for the MI&D was started, they go to this facility and they end up leaving with the MI to another route. So we have some definitions sort of outlined as well. I was wondering, in terms of the automatic revocation that happens at 60 days, if your group talked about considering other timeframes for that and whether that makes an impact. And maybe that's part of a different work group discussion because it's based on statutory language. I don't know, but. Yes, so that is supposed to be a work group 9, which I think isn't necessarily happening in the same way. So we did start exploring that a little bit. Okay. So at the end of this, we did just recommend that be evaluated. We talked a lot about people who are coming back with maybe physical health needs or a voluntary return that won't be much longer than 60 days. And how concerning that is if that ends up resulting in that revocation. Yeah.
Was there a conversation, I guess one of my reservations, with like the, assessment location is based on trends and data, whether or not that would, my fear is that it may be a temporary, resolution or solution. Because my perception is that, some of the delays in, movement through treatment or the assessment, it winds up getting plugged for some of the reasons that we talked about, our complex populations, right? So like folks with intellectual developmental disabilities, individuals that are opined unrestorable multiple times, and some of those influences about how they're able to continue to advance in treatment. I just felt like I needed to say that out loud, is that it may be, in my mind, more of a temporary solution, where ultimately, if we continue on as we are with rates of commitment, those types of things, until we're able to expand community capacity, it's just addressing like the influx on one end, but not the other when it
This
comes
is
to the
just
outlet.
one part
Yeah.
of what we've talked about.
Yeah.
So there's more to address what you're.
Yeah.
Okay, all right, because I'm like, oh.
This is part one,
Okay.
like a 3 part.
And then my other question when it came to privatized versus state-run, less settings, is if we have looked at other models that may promote expanding community capacity, because I do think that there are some providers that are willing and reputable to work with our population. I don't know that there's been necessarily a structured or diligent effort towards expanding that in a good way. So I mean, we know why Shiloh's works. It was started by folks that worked for the state and are very collaborative in partnership in terms of customizing placement and settings. But I can't help but wonder how we can continue to get towards having that more regionally appropriated in a way that still fosters that for folks versus, solely delegating it back on government facilitated. And I will also say, I also believe that we need expansion, right, of MSOC's programs too, because there is a group that really does need that level of support. It's just, I don't know if it's the majority of the folks that we see needing.
One of the things we talked a lot about is trying not to reallocate the resources we already have. Because the whole point of this was to talk about what are the hurdles, what are we missing?
Yeah.
Because we're always gonna have clients who need those other private sector positions that are really high needs folks don't get to use. Well, somebody's still getting to use them. It's just not our high needs folks.
Mhm.
And so we talked a lot about how, if we're asking the legislature, give us something to actually make a difference, something I could sell to county attorneys to say, hey, give this a try. What is that? And it's not just reallocating what we have, because there are plenty of clients coming out of MHP who are still gonna need Shiloh's homes and just their supports and those we don't want those to disappear because now they're being reallocated, because that's all we've done for the last 15 years is reallocate.
Mhm.
And
not expand capacity.
not expand or not offer, something more robust,
Mhm.
because that's what we think we're missing as far as for our high needs utilizers. I'm not talking about
Mhm.
our other folks who
Right.
are successful on MI commitments. We're talking about people who are cycling in and out and or commit that really high level of offense. Well, maybe they don't need to go to St. Peter, but they need to go somewhere more secure to give some community comfort, but also to give that person the support they need that isn't necessarily in existence right now.
Exactly. I think we're seeing the same thing when it comes to, it's just like who fosters it. And I'm curious just from like a business management model, how that could be expanded even further beyond what we've attempted since kind of really rolling out Olmsted, those types of things. I know a lot of counties have set up different structures to develop community placement options, but it's spiraled a bit. It feels like it has spiraled for the last 10 years. And maybe one of the symptoms of that could be that there's 87 different ways of navigating it, those types of things. But is there something that we could do in order to centralize a structure for expanding programs with the fidelity and level of service that we need? So that's just my thought with it.
I think that's exactly why we landed on the statewide model, because
even if it was more regional, because when we're talking across the state, like you have pockets of areas of expertise and you have a majority of a state with none. Like finding even one adult foster care home in some counties is impossible. And so trying to find a way to make that regional, to develop that expertise, to make sure that it exists, because it's a barrier at the beginning and at the end. And so one doesn't work without the other. And so when we were talking about that, like assessment facility, we were thinking, you know, that facility doesn't do us any good if there aren't places to have people go afterwards. So we need that. And there might be people who end up not committed MI&D through that process as well, because they might stabilize, receive treatment, and be able to find some of those more local options with that length of time available to them as well.
Just curious, were there any conversations about like locked birth facilities? Because I know, like, I've heard Sue talk about that kind of in other areas too, so.
Yeah, we did, I don't know that we called it an IRTS facility in our descriptions here, but we did have that everything with that like flexible lock model, was one of our recommendations, yes. Because again, we see that at the beginning, like where you could maybe deter from going to forensics, as well as on the discharge level, like knowing that there are some secure, well-monitored locations, I think would make a big difference for a lot of stakeholders when they're looking at those alternative placements.
And including in that much higher level of education for the people that are working in those facilities. Because that's also on the front end. All of these people that spoke, including myself, when you look back on that and the number of frustrations you've had because they weren't trained and they didn't know how to, you know, they didn't really know how to handle the situation. They were bodies there,
Yes.
but poorly trained.
That's another reason we landed back on state, because we talked a lot about the MSOX homes and how amazing they are compared to some of our private adult foster care settings that we've had clients in, and it's night and day different. The
Well, there
level
are
of
certain-
patience and expertise.
There are certain cases where they're in group homes consistently and the person's assaulted and things like that. And people are like, I get paid $7.50 an hour.
Yeah.
Nope, I'm not doing this.
Right.
And so having a state trained training protocols and safety protocols and all the things we do when we go work for the state, right? I work for the state and you went through all of that stuff and you understood how to manage situations and you were paid decently, you had good benefits, you were willing to engage and work there. So.
And
I
some of
agree.
these people just aren't invested.
Correct.
You know, my son was at a place, they were college students, they walked across the street to the house. We called 6 times prior to what happened. Somebody speak to our son, somebody speak to our son. Did you talk to our son yet? Well, no. Oh, and it was just like, right, there was nobody there. They were there, but they didn't.
Well, yeah, they weren't mature enough, they didn't have the training.
It was
Exactly.
a job, it wasn't a.
Right.
Right.
And if they had been, and I'm not, you know, at the time, very angry, but if they had been, the whole thing could have been prevented. And so, you know, you look back on that and it's hard to get over the kind of anger that comes with that.
So just again, to clarify, what kind of facilities are we talking about here? Because I've heard some terms being thrown out, like state-run facilities, you know, group homes. I mean, did the group have like, you know, thoughts around what kinds of facilities we're talking about for this specific population or populations?
For the assessment facility, we were thinking of kind of more in line with like a secure IRTS, only it is longer term. With that ability to have those recommended timeframes for up to a year so that people could be evaluated and assessed. For the other options, we were thinking more of the community residential settings, like the MSOX homes, that would be developed throughout the state or regional. Yes, yeah, exactly. The thing that we know that we would run into though is that need to continue development, because a lot of the individuals who may end up maybe diverting from the forensic mental health program to one of those homes, that may or may not be long-term. And so is there a threshold for when there are private providers who then are connected with that and who are the next step? Or what happens from there? That, I mean, that part I think remains a question.
This is
Lisa again at the Ombudsman's Office, and I just want to throw out there, yes, these are all models that we talked about. But I think that part of what we also talked about was not being limited to kind of what we have existing. And so imagining what might be ways to support people in the community, knowing that, you know, that 4-bed group home model isn't necessarily what everybody with a serious and persistent mental illness, you know, wants or needs in order to be supported in the community. So just even as we're talking today, I know we're kind of tossing out some examples, trying to summarize a much broader discussion over many, many meetings, but really thinking about what is that full continuum so that we can meet people's needs in a person-centered way that supports them in moving forward, as well as provides the safety and security that they need.
Yeah, we talked about almost like a senior living environment of sorts, where you have every level of options all within your same campus, your same community. So persons who, like the family members talked about, they can live independently, but they still need some supervision and support. Give them an apartment complex to essentially live in, but they stay near their community. And again, these are residential or regional. So in theory, they're close to family and friends. So family doesn't have to travel 8 hours just to visit their friends or family. But if, you know, they're not doing well and they need to take a higher level of care for a time, that's still within this like campus setting, and they can move to a higher level of care without a revocation, without a big SRB and CAP process having to restart, but just moving them through a continuum of care that allows them to still feel part of the community and not, because one thing I've seen a lot, and I know this has happened a lot, is when our persons go to facilities or IRTSs or group homes, they are sent all over the state. And they have to switch providers, and they have to, their county case manager might not be able to visit them as much if they are 8 hours away. So the whole idea was to, if we're dreaming big, can we make it more like a community setting for people at whatever level they're currently processing at, but get to keep their providers, get to stay close to family.
I think we even added, even talking about that community and having a psychiatrist office there, a case management office there, having everything there. So they can practice going to an office and making an appointment and following up with their care and really trying to make this a community for them. So they're, you know, they're stable. They're more stable that way. They just are.
And I just want to caution us here, because that is exactly what the forensic mental health program is, right? We have a continuum of care, right? And so we've built that in. I would just caution us from replicating those settings in the community again. So just wanted to throw that out there, because again, we're talking about recommendations, what can be done in the community. And I get that. We want a continuum of care, but when you talk, you know, in that way, it sounds almost like we're creating another institution, which we're trying to avoid that. You know, so because we're trying to meet the patient where they're best suited in the least restrictive setting.
If we can create it to avoid having to come to FMHP.
Right.
So that at the point, the person maybe has a D, but they've been stable. Maybe they've been at the CVHHs for 9 months, totally compliant with their medications, done everything. Yes, they committed a felony and they have an MI&D, but for 9 months, they've been stable at a CVHH and done everything they're supposed to do. And now, because we have a bed, they're going to come to the FMHP. Sit there. It's craziness. Or the person at Anoka that has been the model patient for a year and a half, and their number finally comes up. Immediately come to FMHP, even though they've done everything they possibly could to become stable. I mean,
That's why that's why I say there's steps here. So if they went to that assessment program, the clinician said, give them a year. You think this person has just had a rough few years? We need to get them sober. We need to get them medicated. We need to find out which medication, because that was one thing Dr. Lindeman brought up is
looking at, because it's
getting the right medication. And then if after a year they're doing fabulous,
We look at other options.
then
It's just right now, it's getting finalized before they even get into any behavioral health.
But they then go to one of these regional placements, whether that's at the IRTS level or at the group home or in an apartment, but either on a stayed MI&D or an MI&D with an immediate provisional discharge or something along those lines to give somebody the chance to avoid having to be stuck at St. Peter if they don't really need it, and to still be able to work with them if they do have a cycle. But we talked a lot about those transitions being so hard on these folks and having to switch all the time, that we were trying to think not of a St. Peter in each place, but of a setting that has options of level of care to meet the person, but in their regional area and without necessarily having to go through the entire MI&D process.
Okay, that's a good clarification.
And that's
So-
what's missing. That's what our gap is, and that's why we end up having them all have to go this.
So like a CBH kind of, but not really.
Yeah, filling in the gaps, yeah.
But I'm just trying, yeah, like it's regionally appropriate.
Yeah.
Regionally appropriate,
Yeah.
it has the level of care, it has providers on site, but that they're free to get jobs. Because we heard that a lot from the parents who spoke, that they can get jobs, that they can be supported in their environment, that they can be near family, and that it doesn't turn into what feels like a life sentence for many of the clients.
And I think, I know, real quick. Crazy making is what it can be. If you have been in a facility like this and you've been doing really well, and then all of a sudden you have to go back to St. Peter, and it's like, what do people want from me? You know, that on a personal level, if it could be handled in that facility, doesn't have to be this traumatic, horrible, hit to the ego or to your self-confidence. Okay.
And there are
We
still
need to
some
move on.
people,
Oh, no.
and there are still some people who will meet criteria and need the forensic mental health.
Yes.
I mean, none of us are in that
Absolutely.
room saying there's nobody who doesn't meet criteria, but
Absolutely.
not everybody needs that level of supervision, support, and care.
Oh,
Well, I guess I think that dovetail, I think the comment about other states and sort of thresholds, I just think that there are moats around this SRV cap process. It exists in other states, but I think I totally agree with you guys that sort of building somewhat of a moat around it of like, it's hard to get there under full MI&D commitment status of SRV cap, every the whole 9 yards. And then also that when somebody has been treated and rehabilitated and has gone through that process, that there's a moat around sort of just, it's not just a free ticket back. I've had some crazy making situations, somebody that hasn't been in our facility for 25 years, and they have an immediate ticket, golden ticket to a bed in our facility because they're experiencing some psychiatric symptoms. And I just like, this is a person that does not, and it's gonna be traumatizing for them to come back to us because it's not even the same place it was 25 years ago. And we've had that happen multiple times. So I think having now a moat to entry and a moat to returning, it to me seems like a way to also promote that community integration.
Yes. Thank you. Sue, and then we're gonna pause and then move on to our work groups, but go ahead, Sue.
You know, one thing I wanted to mention is, and maybe we can bring Ally Skelton in, is that, Rising Cedars was created for a lot of these kinds of folks, right? Who have, been through numerous commitments or been in the criminal justice system. And it is kind of like assisted living. People can come and go as they please. They can work, they can do all those kinds of things, but they have the intensive services there because there are, I think I want to say 33 apartments. You have enough people on a caddy waiver, frankly, to hire mental health professionals. They have a nurse on staff, right? I mean, you have more people there who have, frankly, better training. And so, but the department won't let us do that anymore. And so it might be good to bring her in to really talk about that model. How can we kind of work around that? Now, maybe 33 is too many. Maybe it should be, 10 or 15 or 20, right? But it might be helpful because those are the kinds of things that we're talking about, right? Where you have people with higher skill levels to support people who have, in some ways, some of the more serious mental illnesses. And I can just try to have a private conversation with her, but it might be good if there's some other people who want to come in on that to really learn more about the model. I've talked to people who are there and they like it. They have long waiting lists, right? It's their choice. So I just wanted to raise that as also something, so we're not always building state operated programs as well. Sorry, Delane, are you gonna?
Thank you, Sue.
Yeah,
Oh, go ahead.
Can I just add, I just also want to, I think, address and just mention that, Minnesota Life Bridge program has 4 homes. They specialize for folks with intellectual disabilities. I think they actually have right now, just 2 people with MI&D commitments that are in those facilities. But that's also a model that's already out there, specific for some folks, and they were kind of supposedly the catch-all. You know, Meadow closed in 2011. Cambridge was open for a very short time and closed in August of 2014. And Lifebridge, Minnesota was supposed to be the specialty group homes, community settings that were serving some of those clients with intellectual or developmental disabilities. And when you think 48, I mean, I don't want to institutionalize more people, but you know, Meadow held 48 clients, and these 4 group homes typically have only 3 people in them because sometimes there's one of the people has a 2-to-1 staffing ratio. So you go to 48 clients, you know, to only, you know, 12 to 13 clients in these 4 group homes. That's not really comparable to catching that certain population and giving them a community setting that's working. So I just think increasing some options there, whether it's state or private, and we do have some wonderful private providers who serve the IDDD population who get, you know, funneled through the security hospital or the forensic mental health program. But I just wanted to say that, just to know that that's models out there as well. And they've got some fantastically trained staff. And, you know, their motto is they're not going to kick anybody out. Sometimes people get in there and they've done something at every group home they've ever been to. And you know, we're not going to kick you out. We're here for the long haul to help you stabilize and figure out what's going to help you work to move to another community setting that's even less restrictive than this one. But I just wanted to say that. Thanks.
Thank you.
Dr. Hutchins, we had just a couple of unrelated things, if I could just mention those really quickly. We had talked about discharge process and some of the stakeholder feedback about making sure that those were individualized plans that were more collaborative in nature. And so we described a few areas that could be considered for a future work group between maybe state and county to assess that situation, how we could improve there. We also identified concerns with county case management being inconsistent throughout the process, not in terms of anybody's lack of interest in providing those services. Our counties want to be there providing the best service they can from start to finish and help with that discharge process. But what we identified was really that lack of funding and resourcing available to counties. Counties don't get targeted case management funds when people are at the forensic mental health program. And so the capacity that a county might have, particularly if they are far away or if they have a high caseload of forensic mental health patient or program clients, getting there to provide those routine services is very difficult. And then we've identified that when you get closer to the discharge process, county case managers might not have that rapport or that understanding then of how a client is doing. That might be, you know, at some point when they're not in transition, if they're a track 2 individual, or at transition when services start to become more consistent. So we talked a lot about how that resourcing would be really important to build in so that there could then be a prescribed practice for counties to provide that service so that the state and the county would know what to expect and how to discharge plan together. And we identified how that could assist with fewer revocations as well. With helping to make sure that relationship was there, as well as those very clear discharge plans that could come from more collaboration, indicating who's responsible for what, so that there's that follow through and accountability. Then a couple of things we just added, like supporting regional ACT teams. We have some parts of the state that have no ACT teams. And promoting the jail consultation services. We just felt, even though that's not where we wanted people, we felt that that was worth a mention, that that's significant to us as well.
Yeah, thank you. Well, thank you. Thank you for your work and thank you for the discussion today. So we are going to break up our large group here. So we will have okay, I'm gonna rethink my strategy here because I'm trying to look at how many people we have in these work groups. So I think we'll have objectives 1 and 2, the original work group, probably move to 168. That's across the hallway. And we're gonna meet, we're gonna talk about would be, you know, to synthesize. I know, Sue, you also wanted some more time because she wasn't able to join us to talk about our original report and also now tackle objectives 3 and 5. And then we'll we're gonna have objectives 7. I think it's a pretty large work group. We're gonna have them stay here because I know Dr. Heath, you're also part of it. Dr. Thompson, and then there are a couple of others online as well who are part of it. So we'll just have you all stay here. Let's see, who all are there, just so that people know that. So it's Doctors Adi and Dr. Heath and Dr. Thompson, Dr. Lindeman, Robin Bodie, Dr. Blunt, Megan, and Becky Robinson. You're going to stay here. And then we're going to have objectives. I think that's it. The 2 work groups. And then for objectives 1 and 2, we're going to room 168. That's going to be myself, Sue, Dr. Griffiths, Megan, Delane, and Ginny. Sound good? And then I think Cassie, you were also going to join our work group because last time we talked about who wanted to be in the larger drafting work group. You volunteered for that.
Can we just clarify, what are we talking about doing right now? I don't,
So this is a working meeting, so we're gonna divide the work groups or the existing task force members into the work groups that we had originally decided upon. Objective 7 was looking at statutory recommendations that had been placed on hold, but this might be the time to bring that group together again now that you've heard some discussion. Or again, maybe you all decide that you still want to hold off and then you want to, look at other work groups first.
I was just asking, because I was on work group 7 and you didn't list me, so
Oh, I'm sorry.
I was a little confused, like what was happening.
Missed your name.
Okay, I'm so sorry, because,
I won't read into it.
yeah, Dr. Thompson and I'm sorry, yeah, your name was here too. Sorry about that. Dr. Lindeman as well.
Was it 7 that I was joining, or was it the first one that you?
1 and 2.
1 and 2.
Yeah.
2. Right.
You can, and what about 5?
Objective 5 is going to, who all are, let me see, objective 5 and 6.
We've already been working on.
Yeah.
It's been working regularly. So did you want to meet again, objective 5 and 6? This is the time to talk
I would
about
say
it.
5 and
Because
6.
we do have an extra room available if folks want to meet.
No, we should probably stay here in 7.
Yeah.
5 and 6 to just join 7.
Yeah. Okay, everyone have a place to go?
I think so.
I see much, right?
Okay, thank you. And,
And Dr. Keith around here.
Laura, you're gonna need to
Yep.
drive down.
And Dr. Thompson.
Andrea, welcome. Welcome. Come to the table. Yeah, no, I'm just gonna go get the rest of the argument. I just read them off for 7. I'm good. How are you?
people online okay with it?
I can chat.
So if we're listed as going and staying.
You decide.
Okay.
Yeah, because there are a couple of people who are part of, there are more work groups, so I'm gonna make you all decide which one you want to vote. Not to that.
Yeah. That sounds you. MI&D.
First, I'm aware. Got a vibe, it's specific for Eric.
I'm just.
I have to see
A lot of.
what's going on. I don't have anybody yet.
Right, there it is. Oh, really? No.
No.
So do we have anybody online? We think. Here we go. No.
Yep, we have Delane, Sue, Dr. Thompson are the 3 on there.
Oh, yeah, I just put this on.
And I'm gonna stop the recording for this section.
3 elements.
And then